interpretation and performance and breach, of course. So here we go. All contracts to be valid and enforceable must be in writing and signed by the parties to the agreement. We know from Chapter 8 that that's simply not true, so false would be the correct answer there, right? Oral contracts are enforceable. There's no question. Now, is it maybe easier to enforce the terms of a written contract? Possibly, because obviously in an oral contract you're going to have some he said, she said types of things, and might depend on witnesses, the conduct of the parties, etc. So interpretation of contracts, it's a matter of law, right? We look to the ordinary meaning of words. We try to take some of the ambiguity out of it, right? And again, we always talk about the trade usage, because in different trades they use different terminology, just no getting around that, and they go ahead and include that, and we expect that in contracts amongst people that are, whether it's contracting or computers or whatever, they oftentimes have their own language. Priority of terms, handwritten is more important, and what you'll often see, and why that comes into play, is you'll often see a contract that's been typed, maybe it's generated from a computer, right? And then we'll make changes in there where they're handwritten changes. Often you'll have people initial those, depending on the contract and who's doing it, etc. Okay. And printed is last, I should say. Here's typed, but then here's printed, which you might get from a computer or whatnot. Okay. And handwritten things are priority. They're deemed to be in a higher order. We're going to take those as being actual. Okay. Typed, obviously fine, and printed, also fine. There's nothing wrong with any of these, but we're just saying that if you had a contract that was printed out of the computer, you typed some other instructions in it. Maybe you had to fill in a blank. Maybe there was a spot where you just changed some things and you typed them. They're going to take priority, or maybe you had some handwritten things on there. That's going to take even more priority in terms of how we interpret that particular contract. Parole evidence rule we talked about in Chapter 8 a little bit, right? Cannot introduce oral evidence in court that changes the intended meaning of the written terms. Okay, so we're going to look to the written contract. If there was an oral agreement made afterwards, we're going to go back and look at that written contract and see if the oral agreement applies or doesn't, basically. So contract interpretation, again, we get some rules that help solve these things, right? We look at the usual meaning, but there can be specialized. We kind of talked about that. So we're going to typically look and interpret things against the party that actually drafted the contract, right? So folks contractors and whatnot, they oftentimes draft their own contracts, or they have their attorney do it, right? They would tend to be in a little bit of a disadvantage when it comes to interpretation, right? And again, as we go to handwritten too, if there's a handwritten note or something in there, typically it would be interpreted against that person. That doesn't mean it's automatic. I mean, if those instructions, those handwritten instructions, fit the contract and there's a real reason for them to be in there, that's fine. They'll be perfectly acceptable. But if we have some question, as to their authenticity, or question as to their meaning and those types of things, then typically we would rule against, right, those additional handwritten things. So duty to perform, this came from Chapter 8 as well, the things that we have to do, right? Ultimately we get a contract and there has to be a duty to perform from both sides. First and most important place to look to determine what the parties to a contract agreed to, go with C, right? The words of the contract itself, again, whether they're written or oral. Conditions of performance. So we might do some things like this: a condition precedent. In a condition precedent, looked a pretty good example of that. Or might say something like this: I've got a little bit of land out in the mountains. It's kind of nice. Maybe I wanted somebody to build a cabin on that for me. Well, the crossing to get to my land, and I don't have a bridge, right? is a little bit difficult. And so we might enter into a contract that would say, the contractor would say, I'll tell you what, I'll come and build your cabin when you finish a reasonable crossing, like a bridge or some other type of a crossing, culverts, whatever the case may be. That would be a condition precedent. I would have to finish that before the contract terms would actually take effect. A condition subsequent might be something like, let's say you worked at the ski resort, or you signed up to go to work at the ski resort. But you might tell the ski resort person, I'll tell you what, I'm only going to work here until golf season starts. Okay, that's a condition subsequent. So you're going to work there, fine, fulfill your duties, they're going to pay you, but when golf season starts, you're out of there, right? Okay, you'll be relieved of your contract, I guess, or your obligations at that point in time. Okay, and then we can have conditions concurrent. And there's probably common things that might happen at the time that the contract's finalized. Hey, Will, you buy a car and the dealer, and it's in the agreement, says we'll throw in a set of floor mats or whatever. Okay, they're not there, but when you go pick up the car and give the money, you get your floor mats, right? That would be like a condition concurrent. And then express and implied, we talked about those different types of contracts, right? That express, the words are actually known, whatnot. The two different types of implied we talked about in Chapter 8. So when we talk about delivery, right, first we look to the contract. Okay, if it's not addressed in the contract, typically we would say payment before delivery. So if you go get your cup of coffee, okay, you might have to pay them before they actually give you the coffee. Okay, you go to a fast food place, typically you pay them before you get your food. Now it's kind of interesting. If you go to a good restaurant, it's just the opposite, right? You get to eat, get to completely finish eating, but those are customary. Those are customary things that we just kind of take for granted. In other transactions, that might not be as customary or as normal, we would expect, and if it came down to it, you would say that, well, the person should pay before there's delivery of the goods. Delivery, there's UCC rules and regs that talk about delivery and what's required and whatnot. Again, probably a half a semester's worth of study, that we're not going to get into that deep. Tender means that you have to make the goods available. If somebody's paid you, you have to tender or make those goods available to fulfill your performance. Now, if you got weather, it's miserable and they can't deliver it on the day, okay, you tendered them, you made them available, you got them to the UPS or the FedEx or whatnot. You may have fulfilled your obligation in a case like that. So levels of performance, first we have complete, right? Fulfill all the duties, payments done, etc., etc. Fallen short after an honest attempt, and that's substantial. Okay, that's substantial. And then material breach, right? Less than responsibly acceptable. So complete's pretty obvious, and material breach is pretty obvious. You don't do much or hardly anything, right, to fulfill the contract. A lot of these contracts we're talking about, building and doing those types of things. So, what would be substantial? Well, let's say you signed a contract to build a commercial building, and you got it all done, but you were relying on a subcontractor to come in and do some landscaping. And the subcontractor's not available, the subcontractor goes out of business, the subcontractor dies, something like that happens, right? And so you've finished the building, it's 95%, if you count everything except for the landscaping. That's going to be considered substantial performance. You'll get paid. You might only get paid the 95%, right? The buyer or the payer, I guess, would have the right to withhold funds to finish the landscaping, but they certainly wouldn't have the right to withhold funds and claim that it was a material breach in a case like that. And so, substantial means that you've done a reasonably good job of getting to the finish line, and maybe fell short for reasons beyond your control in some cases. Divisibility of performance. We're not going to talk a lot about this on the test, I don't think either. But employment pay periods, they're divided up. It does say in the book, and it says otherwise, and having been involved in construction contracts, in the banking, I always thought, oh, they must be divisible, because we would get, you'd have a $3 million project. I think the biggest one I was involved in was 3.5 or 4 million, something like that, and you'd get architectural certifications, right? So the builders would come in and they'd get going, and they'd get done with, let's say, 20%, and the architect could come and look at it and say, yeah, it looks like about 20%'s done. And so as a bank, you'd release 20% of the total funds. Maybe if it's a $4 million contract, 800,000, you'd release that to the person that was having the work done, so that they could pay the contractors, et cetera, so they could go on. But that's not generally considered divisible. That's just considered a part of the overall contract and contract terms. So yeah, I don't think I have anything on the test for that, but I'm glad you got to listen to me explain it anyways. Okay, contract discharge, right? So these things can happen. Okay, a discharge is a party released from obligation. It talks about waiver release, and even in the book, I think it says, the difference between being discharged and a waiver or a release, while there's a subtle difference, it really means the same thing. Okay, and so again, I wouldn't get too caught up in trying to know the difference, but know that parties can be, and it could be considered either a discharge or a waiver or a release, can be forgiven for not finishing their performance of a contract, if forgiven is the right word, right? Okay. Certainly a contract can be discharged if there was performance that's complete. Okay. If performance was tendered but rejected, right, then a person might be relieved from their obligations. Okay. Impossibility. Think of you contract with XYZ company to come and do the plumbing in your business, and the XYZ is a small little plumbing shop, and it's a dad and a son, and the dad dies, and the son just doesn't have the ability, right, to finish it. That could be considered an impossibility, right? Commercial or any case like that, the business goes bankrupt, the different things like that can happen, right? Commercial impracticability, okay? This might be a good example of this over here, right? So events beyond one person's control might prevent them from being able to complete their obligations. And that could happen. Maybe you contracted to get some seed from the seed company, and all of a sudden the seed company, their supplier doesn't have it, can't get any in, the type of seed that you're looking for, on and on and on. Might be considered a commercial impracticability, and they could, in fact, it's going to be a case by case, but they could, in fact, be released from their obligation. Waiver release, we've talked about that. It's just like a discharge, or basically something like that. Substantial performance will kind of hit performance part of a divisible contract. So again, an employment part, might be discharged then from past obligations, basically. So duty of performance under a contract is discharged because of commercial impracticability and impossibility of performance. Yeah, can be. Yeah. And they're case by case. If that plumbing firm was huge, and it was the boss of, it's XYZ Corporation, have 40 employees, and the son's the vice president, that may not be considered impossibility of performance, right? Because you contracted with the company, not with just the dad. Efficient breach. What if you could walk away from an economically harmful contract, yet fully compensate the other party? You've breached the contract but made restitution. Do you owe the other party anything further? That's always kind of interesting, So, so you contract to, maybe you're the Senex Harvest States, right? And you offer to. I'm trying to think how that might work. you offer to buy some grain, right? But the grain markets move against you, okay, or move in a different direction, right? And you can buy the grain for cheaper, you know. If you pay that farmer, yeah, that one doesn't make sense. Now, what they're usually talking about here maybe is if you borrowed, you go back to the financial crisis, and if you borrowed money to buy a house, okay, you finance the house. Let's maybe say it's a car, right? So, and you can't make the payments, but you're a good, honest person, and so you take you sign the house back to the bank, or you sign the car back to the bank, right? You've made an effort anyhow to fully compensate the other party. You've reached the contract. Do you owe the party anything further? Yeah, the courts take different looks at that. Okay, and in housing, maybe, and more likely, maybe not. Okay, in cars, absolutely not. Right, the court would still say that you would owe if the bank took the vehicle back and sold it in a reasonable fashion, commercially reasonable fashion, you would still owe the difference, right? So it's really a case by case example, I guess, of what could happen in these things, right? Could such an act harm you in the future? The answer is yeah, it could. And again, it kind of depends. If you went in and talked to the bank and you had an agreement, I'll tell you what, I just can't make the payment. I'll give this back to you as long as you guys don't come after me, don't sue me for the difference. Might be okay. Let's talk about principal agency. Okay. So, and we hear about agents a lot when we talk about professional sports contracts, but agents happen in everyday life too, all the time, right? So the contract can be negotiated. First, an agent, this is what this is saying, the agent negotiates contract with the third party, right? And the principal is bound if the agent was authorized. So if I authorize an agent to act on my behalf, I give them that ability, I'm going to be bound by, so the principal is negotiating with the agent first, and if the principal and the agent have an agreement, and the principal says, yeah, the agent can act on my behalf, and they make an agreement with the third party, okay, the principal can be bound by that agent's agreement. Think in employment sense again. Generally speaking, a lot of corporations anyhow, the officers and whatnot, and the day-to-day folks of those corporations are agents, and they have the right to bind that corporation, by entering into agreements and doing those types of things. Okay, think of it also. I think about this as my mom's getting a little bit older. Let's say she's the principal and she negotiates with me to be an agent on her behalf. Okay, it might be something as formal as a power of attorney, right? That would be an expressed agency agreement. I could enter into different contracts then on her behalf, and she would be bound by those contracts. Okay, and I've seen limited powers of attorney often. We used to see those a lot of times if, a married couple, and boom, he gets transferred, we'll say, and it's middle of the school year, and she says that she wants to stay here and let the kids finish out the school year. Boom, he's going to be off working, right? So he would sign a limited power of attorney saying, well, she has a right to, sell the house on our behalf, to enter into those types of things, certain things. Okay, again, that's principal and agency agreement, and she could then enter into agreement. She could sell the house, even if it was for 20 grand less than what he thought it was worth. He would be bound. Okay. So agency authority can be actual, and actual is oftentimes expressed or written. Okay, and it can be in a job description. Right. Again, if you're the vice president of XYZ Corporation, you have certain actual authority. It can also be implied or apparent. Okay, and implied is through the actions of a company, you give everybody else the impression that Joe can act on behalf of the company, right? And you've allowed Joe to do it. Okay. And so everybody could assume then, even though it's not written or in any other fashion designated, if Joe's gone about doing that type of business for the company, then that would be an implied authority. Apparent authority is oftentimes just judged by the circumstances. Okay, and again, it might be a title. If Joe's the vice president, you know, if you're dealing with the vice president of a company, say, or the CFO of a company or something like that, you don't generally ask, to see the person's job description to know that they have authority to act on behalf of the company, right? It's apparent because of the title, okay? And it would be, it'd be upheld in a case like that, even if there was no actual or written necessarily authority. Contract outside of an agent authority may be ratified and become binding. So let's go back to my mom and myself. Maybe we don't have an express written any type of an agreement, power of attorney or something, but I enter into something on her behalf, okay? And if she agrees to that, she could ratify that. She could say, that's okay, I think that's a good idea. She could certainly ratify that, okay? That just makes kind of common sense. And that's typically what it would be, is kind of common sense. So is there a tort liability? Yeah, remember the principal's going to be held liable under the respondeat superior. Again, it's kind of the employment situation here. Wouldn't always be an employment situation, but it's kind of an employment. If the harm was caused within the scope of the work, and I want to tell you how that is extremely broad. It's very, very broadly defined. Okay, I'll go back to my days as a banker, and my ultimate title was senior vice president. There wasn't, I don't think you could say, a time when a lot of my actions weren't within the scope of my work. Okay, and I know that sounds a little bit too broad, but literally, if I was down at the bar and bought a drink for somebody who was a customer or a potential customer, that's within the scope of my work. Even if I paid for that personally, it would be probably defined that way, and so it's very broadly defined. The example I'll give you is a little bit off topic, but I think it gives you a good feel for how broadly this is defined. Years and years ago, there was a case where, excuse me, had to sneeze. There was a police convention or meeting or continuing ed or something. It was going on in Great Falls, and the cops got together, and they were all staying at I think it was the Holiday Inn at the time. It might be called something different now. And they had regular meetings during the day. Yeah. And then as evening went on, they had dinner. And during dinner, of course, they were having some beverages and whatnot. And then after dinner, I think they had a little get together. And then after that, some of them went up to one of the other, or somebody had a room, very top floor, and they continued to party up there. Okay, and finally, at about 2 or so in the morning, one of the guys stumbles out of the party and stumbled over the railing in the atrium and fell, I think it was about 3 stories, to his death. And his family sued workers' comp and said we should be entitled because what he was doing was within the scope of his work. Okay, even though he's off duty, he wasn't getting paid for it. He'd obviously gone to the convention, for the purposes of enhancing his work or enhancing his workplace and doing those types of things. And so they argued really that every minute that he was gone, it was within the scope of his work, and so they should be entitled to workers' comp. And the courts agreed. Okay, the courts agreed and broadly defined it that way. And so, when I say that it would be broadly defined as an agent representing a company or whatever, it would be, very broadly defined. Okay, there's few actions, especially if you're an officer of a company that you would take that probably wouldn't be defined as being outside of your work. Again, it probably depends on the type of work and whatnot that you're involved in. Understanding contracts is critical to conducting business. Oh, so absolutely. As a banker, we had to know, the contracts that we entered into, the loans and those types of things, but also you had to understand that if you were funding a builder, you had to recognize whether the contract he or she was entering into was worthwhile. right? So you had to understand and you had to know that the protections that were in the contract, the enforcement that would take place, those types of things. It was every day, constant, right? Okay. Applies to both your personal and professional life. Again, yeah, you're going to enter into some of these contracts. You know, when's the last time you went through an entire day without some sort of a contract? You haven't, probably. At least since you reached the age of majority, you probably have never gone through a day where you didn't have some type of contract affecting your life. So there you have it. Thanks. This was a little bit quicker.